I declare open the Legislative Council Legal and Social Issues Committee public hearing for the inquiry into the management of sex offender information.
We understand that there is unlikely to be a more vexed or controversial issue in the justice system than sexual offences against children.
It is very regular to have clients come and speak about the fact that they're on a register. They committed offence when they were 18, 19, and that might be 6 or so years ago, that they're now in a stable relationship, they're in employment, but the difficulties that are being created by their ongoing registration are hampering their prospects of contributing to the community.
In relation to the proposal for child sex offender identities to be disclosed in a public register, this sanction should be imposed immediately upon verdict, which makes it swift, published in every newspaper in the country, which makes it severe, and unable to be overturned on appeal, which makes it certain.
People plead not guilty because of the register. People will run cases because of the register, because of its mandatory nature.
What past advocacy has the Law Institute pursued in relation to a Sex Offender Registration Act?
We have continued to be opposed to an automatic and mandatory registration of sex offenders. Yes, I think that has been from the beginning. My submission is that it must be evidence-based whether or not someone should be placed on this register, and it should be determined by a judge.
Have you found there being any link at all with people accessing more and more child pornography and then acting out on it, or does it remain separate things?
Well, there'll be a small proportion of people that may well use more and more child pornography and go and commit offences. But what you'll generally find is that child exploitation offenders, once they're caught, the recidivism rates are really low. They're quite low. They're somewhere around 3 to 5%.
I've already argued that I think child sex offender register should be made public, but I want to clarify scope and say that I do not think that the names of juvenile offenders should be made public.
Education and rehabilitation is the key. What is telling at the moment in Victoria, in our criminal justice system, is that outside of a court order, I can engage my client in any number of safe driving courses, in any number of anger management courses, drug, alcohol rehabilitation courses, you name it. But I can't get them involved in a proper sex behaviour education program outside of a court order.
In Western Australia, you can access a disclosure scheme, for instance, put someone's details in, and you can be informed whether or not they have prior history with child sex offences. What's your view on that type of scheme?
Knowing that information isn't really going to help. There's going to be a tendency for us to tell other people because we want to tell other people to protect other people, and we're going to end up with the whole vigilantism thing. And I think just knowing ultimately it's a slippery slope to increasing somebody's risk.
And I think the public register comes from people wanting to be able to actually make that report that there is a known sex offender working near a school or working with children.
The impetus behind a public register, I understand it, and I get that it comes from a good place, but it's not going to give the answers that people want.
So with that history of submissions and position on the Sex Offenders Registration Act, does Liberty Victoria have a position on how the Act in its current form balances really community safety concerns with the rights of victims and offenders?
We do. Our view is that there are far too many people on this register.
Okay.
Our view is that mandatory registration is it's an anathema to justice, and it's not going to assist in the proper protection of the community.
Is there the opportunity for rehabilitation within prisons? So serious rehabilitation attempts made in prison for those serious sex offenders?
Offenders who are sentenced to prison are required to undertake sex offender programs before they're eligible for parole.
Can you explain to the inquiry what Liberty Victoria's view is on if there would be any circumstances in which the details of convicted child sex offences can be made public?
Well, in short, in public, if we're talking about publicly available to people that can access it, the answer is none.
To conclude, I'm in support of the full public disclosure of Victorian child sex offender details. I think it's a logical and prudent step to take in preventing future insidious attacks against the greatest asset the state of Victoria has, children who are our future.